like one that might be somebody else's. But you can just start going down the list.
And Your Honor, I'm asking my assistant to bring over the paper. One of the ones that was on the docket, left over on the docket, was Mr., you ready? Mr. Willis? We'll just address that then in a few minutes.
Who's this?
Riley. This is Mr. Riley. Kelvin Riley. He's before the court on 22 CF 295, violation of probation. We're
All right, so this is Kelvin Riley, and this is just 22 CF 295 VOP.
Yes, Your Honor, we're entering a denial at this time.
When would you like to set it?
If you could set it off for a month, I just gave him his score sheet. We're gonna need to chat some more.
So after the 30th?
Yes, Your Honor, please.
What's our next? February 6th
Tuesday.
at 9 a.m.
Yes, Your Honor, thank you.
See you then, Mr. Riley.
Your Honor, this is Kyle Smith. He's before the court on violation of probation on 23 CF 1667. We're going to enter a denial at this time. Your Honor, if we could put this one on February 6th as well. I just got through conveying the state's offer to him.
February 6th. Are we asking for that to be with subpoenas as an
No,
evidentiary
Your Honor,
hearing?
just 9 a.m.
And same thing for Mr. Riley?
Yes, Your Honor. At that time, we'll be able to say subpoenas or no subpoenas after
Okay,
that.
just want to make sure.
Yes, Your Honor. Okay.
Yes, ma'am.
Your Honor, the next one that I had listed on the docket, on one of the dockets is now on the afternoon docket, and I had told him to come in the afternoon, because the notice of hearing was the afternoon, and I believe the
Who's
clerk's,
that?
Mr. Williams,
Which William?
Mark Williams.
Okay. I don't know if you meant Charles Williams or Jay Williams, or I just want to make sure we're getting the right Williams, Mark Williams. So he's on the, you told him to be here in the afternoon.
Yes, Your Honor, our notice of hearing was for the afternoon.
What type of hearing is it?
Bond modification. And the last one I have, Your Honor, and I'm just waiting for, I asked my assistant to bring it over, is Robert Willis is listed on the docket, 21 CF 3281. He pled out the other day, so this was just left on the docket.
Not on my docket, so I must
Oh.
have a newer docket.
Okay, it's on the docket I
So I
have.
wait for the last minute. to print.
But, Your Honor, part of the sentencing was he was to have no contact with the victim unless the victim requested in writing, and we have that. And in speaking to probation, they actually have to get approval from you.
Okay.
So, once I get it, I'll bring it back up to the.
Your Honor, if he had provided a affidavit to us, which we would ask, we would say, hey, the victim comes in our office, we get them to fill out an affidavit saying.
And go tell the victim who you're not supposed to have contact
Right,
with.
right.
Make sure you write that affidavit.
He can't tell her to. But if the victim came forward. and
Well, she
filled
just
out-
happens to find out after you tell them. She's, okay.
And what we were trying to do is get it before the court. If he provides it to us, or if she provides it to us, then we're gonna take her affidavit, e-file it, and send an order to you and say, hey, look, Judge, here's the affidavit we have, per condition 16, it says no contact, she's requesting contact. Will you allow contact, and we'll have an order, and if you wanna sign the order, you would sign.
Typically, does the state want any reason to be heard about that first?
No, Your Honor.
Okay.
It was part of the sentence.
Yes,
Oh, I understand. I just,
but thank you.
I'd rather ask that way, you know, something happens later, like, hey, we never got a chance to give our input on that. I just want to make sure. It sounds like y'all don't want input. If that ever changes, obviously, make sure you tell me. Or if we've got a situation down the road where, you know, contact can be changed with the affidavit, but we'd like to know about it for, you know, just make sure we're spelling it out so everybody knows what, if the case is different from the normal.
We just didn't wanna get in a bind, we didn't wanna put Mr. Willis in a bind.
I understand.
He wants it done immediately. We tell him it's not gonna get it done immediately. Couple process, really.
Well, the big thing is just, it's easier to fix on the front end by having that discussion, making sure the victim's okay with it at the time, as opposed to trying to fix it later. It just takes more time to do it. It's just. All right. Anyone else that we're ready to call?
Yeah, we can.
Oh. You're not ready. Okay.
He's going to need a hearing aid. Okay. Judge Charles Russell, Public Defender's Office. This is Herbert Atkins. He's number 6 on page 3 of your docket. Case number is 2007 CF 622. This was Mr. Gibbs' case. I'm going to ask for some time so I can get with Mr. Atkins and figure out what we're supposed to do on it. So I'm asking for the February 6th docket at 9.
Your Honor, I'm here for Ms. Barrickman, and I have...
Mr. Atkins, do you understand all that?
Yes, sir.
All right. Mr. Russell, is this a more permanent reassignment at this point?
Can I approach, Judge?
Sure.
Hello, this is Chris Norman at Bulldog Bail Bonds. Our office is in Crestview, Florida, but we service 7 Northwest Florida counties. If you ever find yourself in a jam, please give us a call. We're here to help you out.
Congratulations, Crestview's very own Dixie Dan Powell of Powell Injury Law, for your recent jury verdict of $11.5 million for your client from a death and injury against an inflatable amusement company. Recognized in 2017 as one of the top 100 civil trial lawyers in the state of Florida, and Dixie is AV preeminent rated. Dixie Dan Powell works tirelessly for his clients, as is evident by this extraordinary verdict. If you're taking your case to trial, be prepared. Contact Dixie Dan Powell and Powell Injury Law, 850-306-2667.
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestview's historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m.
All right, so Mr. Atkins, we're going to put you on February 6th. Mr. Russell's going to speak with you about your case, and then we'll see you back on that date. It's 9 o'clock.
Judge, this is James Carnes. He's on the docket, number 7 on page 3. Case number is 22 CF 1268. That's a violation of probation. Mr. Carnes also has a new law violation, 24 CF 2782, that's set on this afternoon's docket. That's your copy. State's filed an information. So on the 24 case, The brand-new case, we're going to enter a plea of not guilty, request trial by jury, and 15 days to file any pre-arraignment motions. I think we've already entered a denial on the 22 CF case, so we're asking that both cases travel together and set them for the pretrial conference on February 24th.
And you've been appointed to the new case?
Yes, sir, we already
Okay,
have it.
Just to make sure that we don't have to get that done or said. All right, Mr. Carnes, you understand all that?
Yes, sir.
All right, then both of your cases, which include today's 22 CF 1268 and then your new law violation that was set for this afternoon for arraignment, 24 CF 2782 will be set for February 24th.
So I'm not coming back this afternoon?
No.
You're not coming
Okay,
back this
good,
afternoon,
good.
no,
All
no,
right.
I'll come
sir.
back and
So if
talk
there's
to you.
something you want to resolve, let's resolve it this morning. Otherwise, we'll see you on that date, although it may be the 26th because you're in custody. We're trying to spread the docket out a little bit more, so we're not here till 7:30 at night like we were the other day. So,
Please.
All right. All right, thank you, Mr. Carnes.
sir.
Appreciate it.
Mr. Carver.
Judge, this is Joshua Carver. This way. He's number 8 on page 3 of your docket. On the docket, it just lists case number 13 CF 3024. He has another case for the clerk. It's 2012 CF 1387, which is also a violation of probation. We'll go ahead and enter a denial on both of those VOPs. He has a third case, for the record, it's 24 CF 2943, that's set for a plea day on January 30th. So we're asking that the two VOPs, the 2013 and 2012 case, be passed to January 30th, so they'll all be together, and then we can deal with them on the 30th.
Any issues with
No objection.
All right, so Mr. Carver, we're going to put your current case with your other ones, and that's going to be January 30th. We're going to put that at 9 a.m., and we'll handle that, the arraignment for the new case as well as these VOPs, and maybe something will get worked out together, but we'll see you back on that date. Any
Yes, sir.
questions?
Thank you.
All
Appreciate
right,
it.
thank you, sir. Mr. Russell, your docket numbers seem to be different from mine, so just don't bother giving them to me.
Okay.
I'm following along just fine. but
Just give the name
my-
of the
my-
case.
My page and number seem to be different than yours.
Okay,
I got
just
a-
name and
I got a
case
different hymnal than you do. so.
Okay, okay, no problem. Judge, this is Zachary Dalton. His case number is 2007 CF 2678. On Mr. Dalton's case, we're going to ask that it be passed for status to February 6th at 9 o'clock. I'll need some time. This is Mr. Gibbs' case that I'm going to handle for a little bit.
Okay. February 6th at 9 a.m. Any issues with that, Mr. Dalton?
No, sir.
All right, we'll see you back on that day.
Yes, sir. Thank you.
Judge, this is Akeem Dixon. Case numbers are 18 CF 2695, 19 CF 562, 19 CF 1659, 19 CF 1660, 20 CF 835, 22 CF 1506, which are all VOPs, and then 24 CF 1598, which is a new law violation. I hadn't been able to figure out why this was on this miscellaneous day as opposed to a pretrial conference day, since he has a new law with VOPs. So at this time, I'm going to go ahead and ask that it be set for the pretrial conference on 2/24.
Your Honor, if I may be heard.
Yes.
The reason why it was placed on today's docket is because this case was supposed to be set for a VOP evidentiary hearing. We decided to set it for today so that we could confer with you as to how you were gonna handle those, because Judge Gonterek, we used to do it in the afternoon at 2 p.m. So what I'm asking now is for those cases to be set for a VOP evidentiary hearing on a miscellaneous date prior to February 24th or 26th.
I think the 30th was getting pretty packed up, so maybe February 6th at, have an arraignment date that day? All right, so 2:30.
2:30 would be fine, Your Honor.
I've
February
been saying
6th.
2:30 because I haven't gone through an arraignment docket yet. Do we usually finish those in 30
It's-
minutes?
It's safe to place it at 2:30, Your Honor.
Well, I'm saying probably wouldn't take as long, that we could maybe do them at 2 o'clock, and so give us more time. If I start if I tell everyone 2:30 and then we finish up by 2 o'clock on the arraignment docket, maybe we're not ready to get started at 2:30 because you told witnesses or things like that.
I can subpoena them for 2 p.m.
Okay, let's say 2 o'clock then.
That's fine.
I would say let's start putting it at 2. I'd rather have it too early than too late. Okay. Again, y'all are used to the kind of the cadence of these court dates and how long they take for the most part better than I am. So I want to make sure that you guys are giving me feedback on that. And again, all things are subject to change based on how it's working. All right.
Thank you, Your Honor.
Anything else from Mr. Dixon?
And can the new law then track with that too, Judge?
Absolutely.
They'll all come on
Yes.
2/6 at 2? Okay. I'm gonna see.
Is that for, that we're setting subpoenas on that, right?
Yes, I'm sending out subpoenas.
Okay.
Yeah.
This was mine.
Is this Miss Dowell? Who's this?
Yes, this is Miss Dowell.
That's correct. We made an attempt to contact Ms. Apkarian. We've left a voicemail. We've not been able to reach her. Made good faith effort. This is, Your Honor, this is the case where I think we set this just from earlier this week or late last week because there was a PTI offer that had been revoked.
Because there was a new case that involved the alleged
misdemeanor.
victim in this case being a witness and/or victim in the new case when there was a no contact provision in place.
Correct. So
I can't find my notes, but that's what I remember about it.
that is this case, Judge.
I think, okay, and just on December 30th, the warrant for the violation of that pretrial release was done.
That's standing.
Your Honor, can we ask to have this for February 6th? And then maybe the state might have an offer.
Is there a new case too?
It's a misdemeanor.
Yes, it
It's
is
a misdemeanor violation of pretrial release.
That's all it is?
That involved, oh, sorry, it was misdemeanor violation of pretrial release, and I believe a battery that went
Okay.
with it? Yes.
I'm just wondering the logistics of a violation of pretrial release in a felony case as a PC arrest that then goes to misdemeanor court. But if it has a new charge,
There were 2 counts.
okay,
Yes.
that's fine. It just,
There would be no objection to February 6th for that purpose.
February 6th at 9 o'clock?
February 6th at 9 o'clock, and we're going to have an offer.
Judge Charles Russell, Public Defender's Office. This is Travis Feeser. Case number is 23 CF 2124. Mr. Feeser's case, Judge, I met with him yesterday at the jail. I'm going to need some time to work on it. For now, we'd like to pass it for a status on February 6th at 9, and then hopefully by then we can figure out whether we're doing a hearing or working something out with the state.
That's without objection, Your Honor. Again, it's Ms. Barrickman's.
Okay, Mr. Pfizer, any issues with that? Any issues with that?
Well, the last time I was in court in December, Judge Gontarek, or whatever his name was,
Yes, sir.
told me I needed to get the court documents I had from Washington State certified, and I got them certified.
Have you had a chance to talk to Mr. Russell about that?
We talked briefly yesterday, Judge. I thought I understood what the issues, I understand what the issues are now better after talking to him yesterday.
Okay.
That's why I'm needing more time to look into it, because I couldn't tell from our file if the issue that he's talking about is going to be dispositive of the case or not. We do have the judgment. I don't have a formal judgment with a seal and all that kind of stuff. I can provide the stuff to the state, and, you know, maybe we can figure something out, but
Okay.
I think I'll need some time. Because
I'm
I
just making
don't-
sure because of the transitions in the division, both permanent and temporary, that Mr. Pfizer has a chance to tell us if there's anything else going on. Sounds like Mr. Russell's on top of things for you. And what we'll do is come back on that February 6th date at 9 o'clock. Again, if y'all figure something out early, you can always bring it in early.
Your Honor, I'm somewhat familiar with this. I can speak to later on.
Okay.
But my understanding is frankly, it's not going to make a difference because it has to be worked out with FDLE.
Okay,
I can discuss that with Mr. Russell
all right.
Offline.
Gotcha. Thank you.
Sooner, so I'll talk to the state.
Williams? Oh, Charles Williams? Sorry, Charles Williams.
Sorry.
He pointed at him, but he just happened to be standing behind you, Mr. Williams.
It happens a lot, Your Honor. Third most
Honestly, I
common.
was still,
Let your brother go first. All right.
I was going to say it happens a lot. Third most common surname in the United States. So,
I've never had that problem.
Judge, I've got Keith Shanklin here. It's case 23 CF 2250. And Mr. Shanklin today is going to withdraw his previously entered not guilty plea in this case and enter a plea of no contest to, in the case, in count 1, to the felony petty theft, which carries a maximum of 5 years in the Department of Corrections and or $5,000 fine. And count 2, possession or use of anti-shoplifting device, which is, again, a third-degree felony with the same maximum punishments. In exchange, Your Honor, he'll be adjudicated guilty, sentenced to 12.1 months in the Department of Corrections, and pay $515 in court costs. And I wasn't, it's the first time I've done one of these forms, Your Honor. I didn't see it on the form, but of course he'll get credit for time served in jail. And I don't know if you need a calculation of that or you'll leave it to the jail, but.
Typically leave it to them to do. If there's a concern about it, he can always file something post-judgment.
And I'll let him know, by my calculations, it's, as of today, would be 312 days. So, here, you sign right here.
So he might get there just in time to be processed and released shortly thereafter. I can't say that, but it sounds like it from the numbers you've given.
Well, I explained that to Mr. Shanklin. There were no promises on that, but 85% of 368 is, by chance, 312.
Well, will DOC give you the 85% before for pre-plea
I mean, I can't guarantee it, but
credit?
my experience is that they do, when they process you in. But
Again, as I like to say, DOC doesn't necessarily have to listen to me on any of those things, even if I do say it. So that's why I leave it to them to calculate.
should I pass this up to you?
Yes, sir.
And Judge, this is a downward departure sentence.
Okay. I know this was the offer a couple of days ago, and I know I needed time to talk about it. Mr. Shanklin, can you raise your right hand to be sworn? Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
Can you state your name and date of birth for me, please?
Keith Shanklin, birthday 5/16/73.
Okay. Say 5/16?
Yes, sir.
That's my birthday.
Wow.
A few years off, but. All right, Mr. Shanklin, you're here in 23 CF 2250. You're currently charged with felony petty theft, third-degree felony, possession or use of an anti-shoplifting device, also a third-degree felony. Both those are punished by up to 5 years in the Department of Corrections. I've been handed a plea and sentencing agreement calling for adjudication of guilt on both charges, 12.1 months DOC and $515 in court costs. That doesn't include the public defender fee and everything, right?
I don't know. The offer just had 515 on it, so I put that there.
All right. So typically there's a $150 public defender fee. This is not a VOP, right?
That's correct.
Yes. All right. And $100 cost of prosecution. So all of those things will be sent to collections since you're a Department of Corrections sentence. You understand all that, Mr. Shanklin?
Sir.
Do you understand
Yes, sir.
what I've just said to you?
Yes, sir.
All right. And is this what you want to do today?
Yes, sir.
Are you under the influence of any alcohol, drugs, or controlled
No,
substances?
No, sir.
Do you have any mental health issues or diagnoses? All right. And did you have enough time to speak with Mr. Williams, your attorney, about this? Did he answer all of your questions?
Yes, sir.
Are you satisfied with his advice and representation?
Yes, sir.
Anyone force, pressure, or threaten you in any way to enter this plea? Anyone promise you anything in return for your plea? You understand by entering a plea that there won't be a trial of any kind, and you're waiving all your trial rights that are talked about in this agreement that you've signed. All right, and that you'd be waiving any potential defenses that you have to these charges. Do you understand that?
Yes, sir.
All right. And what is your plea?
No contest.
All right, I'm going to accept your no contest plea as freely, voluntarily, knowingly given in 23 CF 2250 as to both counts. Adjudicate guilty, 12.1 months Department of Corrections, 515 court costs, 150 PD fee and application. as well as $100 cost of prosecution. This is a downward departure that the state announced based on plea bargain.
That's correct.
All right. They will run concurrent, yes, ma'am. Oops. 12.1 months. All right. There you go, Mr. Shanklin. That's all. I need you to be fingerprinted. You have 30 days to appeal the judgment and sentence. Again, we can't tell you anything about the credit for time served, but you'll certainly be out by our birthday. All right. Thank you, Mr. Shanklin.
And next, Your Honor, I have State of Florida versus Landon Whittington. And those are case numbers 24 CF 444, 23 CF 2875, 2876, and 2879. And I believe we just have a status review this morning, Your Honor. You wanted to make sure that Mr. Whittington knew that even though the other day there was a little hiccup in getting him in front of the court, that you were aware of it, and he's aware that you're aware of it, and we're working on his case.
Okay. Ms. Leone, anything you want to add?
No, I discussed the matter with Mr. Williams, and we were going to ask the court to set the case for next pretrial.
Sure. The cases are getting a little on the older side, so I'd like for, some idea on what we're doing. Is there any discovery outstanding or?
Not that I'm aware of, Your Honor. We did, Ms. Leone and I have discussed the possibility of getting our investigators together and exchanging some information that may assist both of us in coming to a resolution. So we plan to do that between now and February the 24th.
Okay.
We should be able to report on it.
And I'm a little familiar with the cases because it was in front of me in my other division. I know there's a lot of out-of-state people involved, right? So I understand that there's some complications. It's a little bit of a more complex issue, but it's also a year old. I'd like to get moving on it.
Well, part of the reason we're getting together, Your Honor, is to see if we can obviate the necessity for some depositions that would really take a long time to set up and do. So we're trying to avoid that.
Okay. All right, well, let's make those decisions by February 24th.
Sure.
Mr. Whittington, we'll see you back on that day. All right, anything from you, Mr. Whittington? All right, I appreciate it. We'll see you then.
And that's all my business, Your Honor, if I could be excused.
Yes, sir. We'll see you next time, Mr. Williams. All right. Mr. Noakes, are you ready?
Mr. Anderson, still need to speak for about 5 minutes on that.
All right.
As far as, I think the next case is Ms. Kamp, and I was still waiting for the final offer from Justina.
It's adjudicate credit for time served, $515 in court costs.
I need to talk to my client briefly about that, and then.
Is she in custody?
No, sir.
Okay. Is she here?
She is.
Okay. So you want to pass that so we can?
Yeah, we just pass it. The other case I've got is we got a phone call from Mr. Rycroft that said he was running late.
Okay.
I don't see him out there unless he slipped in.
Well, why don't we see if he gets back here by the time you finish up your others?
Very good. Thank you, Judge.
All right. Thank you, Mr. Noakes. Okay, let's call them. Who might that be? Jessica Fickett. All right, good morning, Ms. Fickett. You're here on a violation of probation in 22 CF 2574. Do you understand that? All right, can you afford an attorney to represent you in this case?
I'm getting one, yes, sir.
Say again?
I'm getting one, yes, sir.
You're getting one?
Yes, sir.
All right. So what I'll do is I'll enter a denial for you as far as your violation of probation. How much time do you think you need before you come in with that lawyer?
For this Friday is when I'm meeting.
This Friday?
Yes, sir.
All right, so February 6th, sound good for everybody?
Yes, Your Honor, it's fine for the state.
All right, February 6th at 9 o'clock, we'll have you come back in. Make sure you come in with that lawyer. If you're not going to ultimately hire that lawyer, say something happens between now and then, you can certainly go to the clerk's office and apply for the public defender so that public defender's office can be appointed before you come back on that date, and you can kind of hit the ground running with them a little bit more than starting new on February 6th.
Yes, sir.
All right, we'll see you back on that date. Robert Lundy. Morning, Mr. Lundy. You're here in 2020 CF 800. That's also a violation of probation. Do you understand that?
Yes, sir.
All right. Can you afford an attorney to represent you in this case?
I'm in the process of.
Okay. How much time do you think you need for that? I'm sorry, you also have 2020 CF 2291, which is a violation of probation.
If I may.
Yes.
The recommendation for probation is to extend by 6 months so that he can make some efforts to pay the outstanding monetary requirements.
Okay.
I'll speak. I'm sure I can pay it, a couple of months.
So they're suggesting 6 months. You say you can do it in less.
Well, I understand, that was a recommendation, 6 months, I'd be fine.
Okay. So I think he's okay with that. Are you asking him to plead to a violation and extend, or just?
He would have to plead for that, Your Honor.
Okay.
The only thing is, well, I'm asking for a modification. He has a withhold of adjudication right now. So, I don't know if the court feels should appoint a public defender.
That's the part I was unaware that.
Well, I mean, when the concern seems to be monetary issues, maybe talking to a public defender would be helpful for you.
I would like to talk to, I don't want another charge on my record,
Okay.
So,
Who would have Mr.?
Talk with the state just as a friend of the court rather than him incur another 150.
Okay.
Another way to handle it,
He doesn't, I know.
if we
I know.
continue that, I don't know how long, Mr. Lundy.
I'm sorry.
I don't know how long it'll take Mr. Lundy to get up his money, but I think it's restitution. So
How much are we talking about?
Needs to be done, but, if we continued it, for a cycle or two, he may could come up with it, I don't know.
Your Honor, I have this balance of $2,900 versus 64. That's the balance that I have.
All right. Do y'all want to talk for a minute about it, and we'll bring it back up, or?
If I may, if we just, if the court orders a modification, he can keep the withhold of adjudication, doesn't have to. When you revoke and terminate and new terms, that's when he gets the adjudication. In this case, he would not. So we can extend it.
It was basically a plea to a modification.
Yes, correct. He admits, but modification doesn't require adjudication.
Okay. Mr. Lundy, you want to think about that for a minute? So what they're saying is you'd have to plea, admit that you violated your probation. We'd continue to withhold adjudication, which means you wouldn't have a conviction, but give you some more time by modifying your probation, give you more time to pay that off.
I understand.
Is that what you want to do today?
Yeah, as long as it's withheld, yes, sir.
Okay, and that's what the state's offer is?
Yes, Your Honor.
Okay. Raise your right hand. Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, Mr. Lundy, you're here in the cases I mentioned, 2020 CF 800 and 2020 CF 2291, which are violations of probation. Do you feel comfortable going forward without a lawyer at this point? Given what's been announced is what they're offering for you to do, and me agreeing to stipulate to with that offer as well.
Make sure I understand. As long as its adjudication was held, and my probation officer said it'd be terminated as soon as like I say, I pay it off 2 months, 3 months, it'd be terminated at that point.
Well, all I can say is it won't be as soon. It's not like the order gets signed as soon as you hand over the check.
Okay.
It still has to come to my office and get signed.
I understand that.
I just, when people say immediately, I want to make sure immediately doesn't always mean immediately. But yes, it would happen. It's just a matter of them sending the paperwork to my office, me signing off on it.
I understand. I'm sorry.
And, if I'm busy with a trial or something that week, it might take me a couple extra days to get to it, but it'll happen.
I understand that
I
part.
guess
Thank you.
the court could announce that it can early terminate upon paying all the monetary requirements.
Your Honor, as long as the order says shall terminate upon completion, we don't have to send another order. And also, if the state and your Honor is inclined to give him a year instead of 6 months, because he's had quite a time to pay it, and I don't know. We would still auto-terminate, but that way we're not back here in 90 days, because.
Cost of supervision is being waived already,
Yes, sir.
so he's not paying
Correct.
more time.
I'd be fine with that.
Yeah, because if not, in 3 months, we have to send another order saying he didn't pay it if he didn't.
Okay. All right, so what they're offering to do, Mr. Lundy, is give you a whole year to finish paying off this money. Is that what you want to do?
Yes, sir.
Okay. So, but you'd have to admit that you violated your probation, but again, it'd still be a withhold, so you wouldn't have a conviction from these cases.
Well, I looked at it, I mean, I was already violated, the reason they took me to jail,
Okay, well, I understand, but taking you to jail is just the beginning of the process.
I understand that too. But it shouldn't be any problem in a couple, by then.
Okay. All right, so what has been offered, and you tell me if you're willing to do this, you admit your violation of probation, I'll modify your probation to extend it for a period of 1 year. Are we going to have any issues as far as how long he was on probation and maximum levels of probation?
We would be extended 1 year from his original termination date, which is 2/1/25, so we would be at 2/1.
Okay. I just want to make sure that he didn't get 5 years on a third-degree felony, and now we just made it 6. Okay, perfect. Thank you, Mr. Berry. I just didn't want to have to look all that up since y'all probably have it at your fingertips.
And then shall term upon payment of the restitution.
Okay, so Mr. Lundy, as long as you pay off all the money, it'll be automatically terminated at that point, and you'll be off probation. You understand that? All right, hold on. Is that what you want to do today?
Yes, sir.
All right. Are you under the influence of any alcohol, drugs, or controlled substances?
No, sir.
All right. Do you have any mental health concerns or issues?
Not at this time.
Have you in the past? That would
bit.
impair your ability to make this decision for yourself?
No, sir.
Okay. Has anyone forced, pressured, or threatened you in any way to get you to enter this plea?
No, sir.
Has anyone promised you anything other than what we've talked about here today
No,
to get
sir.
you to enter this plea? All right. But by entering a plea of admitting your violation of probation, you understand there won't be a hearing where they have to prove that you've violated your probation because you'd be admitting to that.
Yes, sir.
Okay. And how old are you, Mr. Lundy?
62.
And how far did you go in school?
All the way through high school, and I took a couple of years of college.
Okay. So you understand everything that's going on here today?
Yes, sir.
Okay. I know it's a little bit complicated,
Well-
so that's why we want to make sure that we explain it to you.
Yes, sir.
Any other questions for me?
No, sir.
Okay. So are you admitting your violation of probation or denying it?
I'm admitting it.
Okay. So I'm going to accept your admission to the violation of probation in both cases. I'm going to modify your probation to extend it for a period of 1 year till February 1st of 2026. You have to pay your restitution. That's still owing. I'm going to continue to waive supervision fees. I'm going to continue to withhold adjudication, which seems to be the big issue for you, Mr. Lundy. But automatic termination of his probation upon receipt of those funds. All right. Now, make sure you get it done. Otherwise, you're going to get another letter, and you're going to have to come back. You might get arrested again. So make sure you take care of that as soon as possible, because we don't want to have to see you back here on this issue. That usually means you probably spend a night in jail. Let's not do that.
Procrastination is not a good thing.
Yeah, okay. All right. Mr. Lundy, make sure you talk to probation on your way out. Ms. Leone, was there something else? Score sheet?
Score sheet.
It's a guideline sentence?
Well, it's a modification, so it doesn't, that's fine.
Okay.
He scores with this score sheet, for the record, 48.3 months.
48.3 months.
Yes, Your Honor.
What that means is, had the state not generously offered to give you some more time and you violated your probation, you'd have to prove to me why I shouldn't put you in prison for 4 years. So make sure we get this paid.
Yes, sir.
All right.
And if I give it to the judge.
All right. Thank you, Mr. Lundy. Make sure you talk to probation. And you have 30 days to appeal the judgment and sentence of the court on the modification.
Judge, I've got a client that's actually in the gallery. He's out of jail. It's going to be a plea.
Who's that?
That's going to be Matthew Murphy. Judge, this is going to be a plea to a misdemeanor.
Okay.
Lesser included offense.
Mr. Murphy, raise your right hand. Do you swear or affirm this testimony about to give is the truth, the whole truth, and nothing but the truth? Yes, sir. All right. Can you state your name and date of birth, please? Okay. And Mr. Murphy, I've been handed a plea and sentencing agreement in 24 CF 1674 that would have you plead to a lesser included misdemeanor first-degree criminal mischief. Is that what you want to do today? All right. Are you under the influence of any alcohol, drugs, or controlled substances? All right. Are you? Do you have any mental health issues or diagnoses? All right. Have you had enough time to speak with Mr. Murphy regarding this? Or Mr. Murphy, with Mr. Williams regarding your plea agreement? Did you go over it with him? Did you sign it? Did he answer all of your questions? All right. And are you satisfied with his advice and representation in this case? Anyone promise you anything in return for this plea? Anyone threaten you to get you to do this? You understand by entering a plea, you're giving up your right to a trial and all the trial rights that you read about in this document. And you're waiving any potential defenses that you may have. Yes? Okay. And what is your plea? All right. I'm going to accept your no contest plea to the lesser included offense of first-degree misdemeanor criminal mischief. I'm going to withhold adjudication on that misdemeanor, require you to do anger management, restitution in the amount of $1,966.83 to Roxanne Martin. That's to be paid through probation. Automatic early termination upon completion without any violations. Misdemeanor court costs are $265. Cost of prosecutions $50. Public PD application fee of $50. Misdemeanor PD fee of $50. Cost of supervision to be waived. Did I miss anything?
No, sir.
State's agreement?
Sir.
Okay. And no score sheet because it's a misdemeanor. Say again, sir. I thought I said it really slow for you. You just weren't ready for it. $1,966.83.
Mr. Berry, I've got an extra copy of the plea agreement I can hand you. It's got it on it. I've got it.
Can you say the word shall terminate? For whatever reason, that's the one.
That's the legal word that
works.
Yeah.
Upon completion of all terms.
All right. Early termination shall happen upon completion of all terms.
Thank you, Judge. Okay.
I know with our office, that's the one we don't have to bring back to court.
Mm-hmm. It's just like every time we be with probation, you have 30 days to appeal the judgment and sentence Mr. Murphy. It seems that's when you look at how they're editing statutes all the time, and it's always changing a must to a shall. I'm like, I don't know the difference. But apparently it's really important. All right, who's next? Mr. Williams, did you have someone else?
Nobody out, Judge.
Mr. Williams? Deputy Williams? Kelvin Holmes? Who represents him? Mr. Robertson.
Yes, sir. Oh, okay. Give me just a second. Bring up Mr. Holmes. If I can inquire, is he on the VOP docket? Or is he set for call today from pretrial conferences?
Not a VOP.
I'm just trying to scroll through to see my notes. Okay.
Let's just plea or continue from Monday.
I think, looking at my notes, looks like the state was needing to talk with the victim. Without that, the offer was plea to count 1 and 3 year probation. Mr. Holmes, where are you? Did I go over all that with you? what did you decide that you want? Are you?
So what's the question?
Well, the question is, what is the current offer? You were thinking it's going to be a misdemeanor plea based on what happened. If it's filed with me, I'd have to run it.
I'm not sure what happened in court.
What do you have as your current offer?
24 months DOC. No, that's what I'm saying.
Why don't we pass Mr. Holmes? If y'all want to bring it back up, we can do that.
It's a plea, like you said, for probation, to count 1 and then probation.
Okay, but
I tell you.
still a plea to a felony?
Yes.
And are you seeking an adjudication?
Well, he's already a convicted felon. He scores 52 points, only prior record, so, yeah.
Mr. Holmes, would you be able to come back for 1:30 this afternoon? That would give me time to the file. Is that a problem for you? Judge, give me just a few minutes then.
All right, we'll pass it. Anybody in custody?
I do. All right, Judge, Judge, I'm going to ask to pass it one more time. We can set it for a contested hearing at that point. I'm working on getting her into an alternative program, and I'll have an answer by then. In fact, she may already, if drug court winds up accepting her, she may be off the court's docket anyway. I've spoken to Ms. Henderson about it.
For the record, that's
Terry Henderson,
from
yes, sir.
court.
I mean, the state's position is she's got the 30-month suspended sentence. I don't know if drug court's willing to take her with that being the case or not. But the state would ask to set this, I mean.
That's what I'm saying. Let's set it for a contested hearing so that we can
resolved one way or
proceed
the other.
if that doesn't happen.
February 6th at 2 o'clock?
I don't know for sure, Judge. Well, February 6th is plenty of time. Yeah, I would think that she'd have seen
4 weeks from now.
yeah, she would have seen the several drug court proceedings that she needs to watch, so.
I mean, I know the newest case is from April, but.
Yes, sir.
I believe these are all three are violations of probation.
That's what I have, Judge.
She was pled in June and violated in August.
Yes, sir.
All right. February 6th, 2 o'clock with subpoenas for evidentiary. Obviously, if you get it resolved, you can bring it in earlier if you need to and cancel the subpoenas, but that'll be our date.
Yes, sir. All right, ma'am. Come on out, Mr. Johnson. Come stand over here by me. Judge, Mr. Johnson's file got opened yesterday. In fact, I was thinking it was a different Joshua Johnson that I have. I have reviewed the documents online, though. I'm going to enter denial from Mr. Johnson at this point, but I'll still need to go out to the jail and see him.
Does that mean you're not setting it for an evidentiary hearing?
No, Judge, I'm going to go ahead and enter denial at this point, and then let's bring him in next time. Perhaps we can get it resolved depending on what the state's offer is.
All right, well, February 6th at 9?
Thank you, Judge.
February 6th, 9 o'clock.
All right, Mr. Johnson, I'll come out and talk with you, okay?
Thanks, sir. All right, This is Colton Keaton, 21 CF 2013 VOP.
Ms. Vaso, are you here from Ms. Barrickman? I am. My understanding is that she's on leave. Are you prepared to make an offer in the case today? Okay.
Have Katie bring some the other day. I spend more time here than I do at my house.
Ready for time served, ma'am?
No, it's from time of arrest.
Oh, time of arrest on the VOP. Okay. Judge, it looks like we've got a negotiated plea. On the VOP, is the court going to require a written plea offer, or will the court do a colloquy?
What's the offer?
Your Honor, currently Mr. Keaton is on probation. What we're asking that he do is admit that there be an adjudication. There'll be a reinstate to all original terms and conditions with the additional term of 6 months, Okaloosa County Jail, with credit from the time of arrest on the VOP.
Which was what date?
It was sometime
I'm not going to give an exact calculation, but at least he knows somewhat.
It was early August, I can tell you that much, sir.
Judge, I can.
What's your name in backwards? I'm looking at August 12th. All right, so Mr. Keaton, the plea offer was admit to your violation of probation, adjudication of guilt, reinstate to all your original terms with a new term of 6 months county jail with credit since August 12th. Is that what you want to do today? Okay, raise your right hand. Do you swear or affirm that testimony about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right, can you state your name and date of birth?
Colton Keaton, 6/24/1989.
Okay, and Mr. Keaton, are you under the influence of any alcohol, drugs, or controlled substances? You have any previous mental health diagnosis? Has anyone forced, pressured, or threatened you in any way to make this plea? Anyone promise you anything other than what's talked about your plea agreement? All right, have you had enough time to speak with Mr. Williams about this? It was just conveyed this morning. Do you think you need more time to talk to him about it? All right,
That's the best news that we got.
All right. Has he answered all of your questions?
Yes, sir.
Are you satisfied with his advice and representation? You understand by admitting to your violation of probation, there won't be a hearing where the state would have to prove to me that you violated your probation in the ways that they previously alleged. All right, and then you understand you're waiving any potential defenses that you have to the violation of probation.
Yes, sir.
All right. All right, and what is your plea? Are you admitting your violation of probation, or are you denying it?
I'm admitting. Yes,
Okay.
sir.
I'm going to accept your admission to the violation of probation as freely, voluntarily, knowingly given, adjudicate guilty, all counts, reinstate probation with all previous terms, with obviously credit for whatever you've completed, but you've got to finish everything that you were initially sentenced to on probation. New term of 6 months county jail. You'll get credit from time served since your arrest in this violation of probation, which was August 12th, 2024. All right. VOP fee is $100, and then $150 for the public defender fee and application. Anything that I've missed?
No, Your Honor.
Is this a guideline sentence? Okay.
And
Ms. Barrickman will get the court score sheet.
Okay, I appreciate it. Mr. Williams.
Your Honor, can I inform the defendant, I believe he was on GPS.
Yes, sir.
He will need to
Be on GPS before released?
Yes.
$1 a day still? Okay.
continue to waive supervision fees.
Waive supervision fees as previously ordered. Yes. All jail and probation concurrent across all 3 counts.
thank you, Judge.
All right.
All right, Mr. Keaton.
Thank you.
All right, you have 30 days to appeal, Mr. Keaton. Do you need his fingerprints as well? We have them from last time. Okay. Was that, was an adjudication last time? Okay. Okay, that's fine. If you want to abandon us, that's fine.
Judge, Mr. Lambert has a new case that's on for arraignment this afternoon, and he's got a case on for, I believe, we're here on a bond motion that I'd filed on his behalf. Now, Judge, this is the first one of these that I've done with you. Judge Gonteric tended to just have us restate the allegations in the bond motion, or the assertions in the bond motion, and then he would ask any questions that he had. Does the court want me to put him under oath and have him go through what's in the motion?
Let me just take a quick look at the motion. Was he on any kind of supervision at the time of the arrests?
Judge, I have it as a new case, arrest date 12/5/24. That was me misspeaking, I believe, Judge.
It's the same case, I believe.
It's the
that's on
same
for
on both
arraignment.
documents.
It's the same on this morning and then this afternoon. When we finish now, I'll go ahead and arraign him.
All right, Mr. Lambert, can you raise your right hand to be sworn? Do you swear or affirm that any testimony you give today is the truth, the whole truth, and nothing but the truth? Okay. All right, ask him any questions that you want him to answer that you need me to know, Mr. Williams.
Judge, I'll try to do so quickly. Mr. Lambert, have you been in jail since about December 5th?
Yes.
Are you able to make this $4,000 cash or professional bond?
I haven't got nobody out. No.
All right. You said you haven't gotten anybody. Is it a matter of, or an issue with getting hold of the funds or accessing your own funds?
Yeah, I guess. I ain't got nobody out there to help me.
Okay. Are you requesting that you be allowed to sign that bond?
Yes.
Okay. You understand that if you failed to appear in court as a result, that you would owe that money, plus you would pick up a new charge and be subject to being held without bond?
Yes, sir.
Are you currently working?
I got some odd jobs, yards to maintain.
Okay.
That I've done for a while.
So basically you do generalized yard and handyman
Yes, sir.
work?
Yes, sir. I'm working on getting a job for Burger King, or I got a couple of things, you know, and working on.
Now, if you're released, where would you reside?
2885.
Okay, 2885?
Yes.
And what's the street?
Wisteria.
Judge, I'll orally amend the motion to reflect that. And is Wisteria in Crestview?
Yes, sir.
All right. Are you going to be living there with anybody in particular?
We just not in particular, no.
Okay. No particular family or something like that?
No, sir. I don't have no family.
Okay. And how long have you lived in this area?
Off and on 20 years or so.
All right. Judge, I'll orally amend the motion to reflect the 20 years as opposed to 25 to 30.
All right. Anything from the state?
Yes, sir. The state objects to the motion to modify this bond. The state's position is that $4,000 cash or professional is a reasonable bond based on 903-046 criteria, the nature and circumstances of the offense. This was a crime of opportunity. Mr. Lambert was walking by the coffee truck and came onto the property to steal some items and did steal them. Under 2C, his employment
skeleton and an RV power cable, right?
That's correct.
Yes, sir. That's the allegations.
His employment history is, I know that his testimony today is that he has some odd jobs, but in the motion it does say he is unemployed. Under 2D, the past and present conduct, Mr. Lambert has felony convictions from 2022, misdemeanor in 21, misdemeanor 3 in 2019. He has a felony failure to appear in 2017, felony in conviction in 2015, misdemeanor in 2014, 2013, 2011. Your Honor, it goes on from there. In 2003, some serious felonies, weapons offenses, and in the 90s, Your Honor, 1996, 1 conviction in 1996 and 3 in 1994 for armed burglary. The state's position is that Mr. Lambert does pose a probability of danger to the community and that the $4,000 bond is reasonable.
Anything else, Mr. Williams?
Judge, I obviously would dispute that conclusion. He's entitled to a reasonable bond. He's entitled to the least restrictive bond that the facts and circumstances suggest. Again, it's a theft of a decorative skeleton and an RV cord.
My concern is this is not a first time around.
Oh, yes, sir.
And this,
Yes, sir.
this criminal history goes back to the 90s from what I heard, including violent felonies and failures to appear. So I'm going to deny the motion.
All right, Judge.
All right, thank you, Mr. Lambert.
All right, Judge, then I need to go ahead and arraign, well, I was going to need to arraign him anyway. I'll enter a plea of not guilty on his behalf, request 15 days for pre-arraignment motions, and demand trial by jury.
All right, February 24th.
Thank you, sir.
For a pretrial conference.
All right, sir, I'll be back to speak to you again once we get discovery and get an offer, okay?
I think the amounts are adequate given the circumstances.
Yes, sir. Judge, I think this is here on a competency review. I have the report from, the last report I have from Appalachia is November 30th. He's been on conditional release with the Appalachia Center. I don't know if the state has seen this. I pulled that up just for today's hearing. What,
Seems like it was filed December 11th.
what we noticed was that people were winding up either in conditional release or at Florida State Hospital, and if we didn't bring them up every 6 months, we would sometimes lose track of them. So that's my understanding of why we're here today. I would request that we leave him in place. I see no reason to, nothing that says he's competent now or anything of that nature, and just bring it up for call as a status check in another 6 months.
To make sure I understand what I'm reading here in the report, it says they're recommending he remain in a residential program, but he's on conditional release, so he's not in a facility. Right?
He's in a residential program at the Appalachia Center, or being supervised by the Appalachia Center.
They're exploring a community placement for him.
Yes.
Did he have anything on this? Or is
I
keeping
wasn't
him on
aware of.
Conditional release.
Yeah, no, I haven't reviewed that document.
I hadn't seen it before today either.
can we
It's,
do?
it's filed in the court file though.
We just continue.
Yeah, we just pass it and bring it back.
Yeah, Your Honor, that's fine to postpone it to
Yeah,
6
for a
months.
6-month miscellaneous date.
Judge, it doesn't make any difference to us. They're supposed to send us a update about every 6 months or so, so we'll probably get one, I'm guessing in about 4 months.
June 3rd.
Thank you, Judge. Judge.
24 CF 2766.
Judge, I believe we're here for a bond hearing of Mr. Nance as well. He's got, the case is also scheduled for arraignment this afternoon. I have met with him. I've gone over the state's offer, but he would prefer that we enter a plea of not guilty on his behalf. So if we can go ahead and have the bond hearing.
Okay. And I've reviewed the bond motion. All right, Mr. Nance, raise your right hand. Do you swear or affirm any testimony you're about to give is the truth, the whole truth, and nothing but the truth? All right, go ahead.
Mr. Nance, have you been incarcerated since about December 2nd?
Yes, sir.
And are you able to make your current bond of $1,000 cash or professional?
Not within jail.
All right. Do you have those funds, but you're simply unable to access them because you're locked up?
Yes, sir.
Okay. Are you requesting a bond of $1,000 signature?
Yes, sir.
Where are you employed?
Bigfoot Moving Services.
How long have you worked with them?
3 years.
And where would you be residing once you were released from jail?
631 Woodruff Avenue.
Is that in Crestview?
Yes, sir.
And how long have you lived in this area?
5 years.
Judge, that's all the questions I have of the witness.
All right, anything from the state?
Judge, Mr. Nance does have 2 prior adjudications for failure to appear, one in 2020 MM 4623, disposition date of June of 21, and also in 09 MM 1254. Does have a record, Your Honor. The concern from the state would be whether or not he's a flight risk based on the previous failures to appear.
I'm sorry, I didn't hear the previous failures to appear detailed. When did he fail to appear?
21 and...
One was in the adjudication date, the disposition date for the first was in June of 21, and the other was December of 2010.
Disposition date of the offense, or was he charged with failure to appear?
Those are
okay.
charges and convictions for failing to appear.
It looks like in 20 MM 4623 had 2 failures to appear, adjudicated guilty on one. The other one was not pursued.
All right, Judge.
Anything else?
Mr. Nance, do you have any explanation for that failure to appear?
No, sir. I'm not aware of the more recent one.
Judge, I don't have anything further than.
For bonds, $1,000 cash or professional. I think that's adequate given the situation. I'm going to deny the motion.
Judge, at this time then, I'll enter a plea of not guilty on behalf of Mr. Nance. Request 15 days for any pre-arraignment motions and demand trial by jury.
All right, February 24th for pretrial conference.
Thank you, Judge.
Obviously, if y'all resolve anything, you can bring it in earlier than that.
Yes, sir.
Thank you, Mr. Nance.
And Judge, I believe that's the last one I have for this morning. Oh, okay. Well, I mean, I still need to.
Morning.
Randy Merrifield on behalf of Timothy Robertson and 24 CF 2001. I apologize, I was with Judge Gonteric. Mr. Robertson is
I have to apologize for that.
present and approaching.
And we've reached an agreement, Judge, if I may approach?
Please.
Mr. Robertson in 24 CF 2001 is withdrawing his previously entered not guilty plea. He is entering according to the agreement that I just handed, Your Honor, and it is based on a legitimate uncoerced plea bargain. And just so the court is aware, we did resolve the injunction on the 7th, like I presented on the 6th. So that was resolved with an extension of the temporary.
There was something else. I just hadn't got to my notes about it yet, but I remember
Yes, sir.
you saying that on Monday.
Yes, and it does have a natural death date on the injunction that won't interfere with the plea today.
What happened with the injunction?
The temporary was extended for 30 days. Then he would enter this plea, and then the couple will certainly address any further contact in the divorce action, and that'll reflect in the felony case on motion.
So this shows no contact with her other than communication through talking parents. Is the injunction any different from that?
The injunction is just a 30-day no contact. There's no provision for talking parents with a natural death date at 30 days.
So the only reason I ask, I want to make sure he understands that what this court does doesn't change what that court does. So if there's a no contact except for talking parents from my case, but the injunction says no contact at all for the next 30 days, you've got to have no contact for 30 days. Do you understand that, Mr. Robertson?
Yes, sir.
And I'm sure Ms. Merrifield explained that. I just want to know on the record that I've explained it to you as well, so you know. All right. Raise your right hand, please, sir. Do you swear or affirm the testimony about to give us the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, and this is as charged?
It is, Judge.
All right, can you state your name and date of birth, please, Mr. Robertson?
Timothy Robertson, born June 25th, 1986.
Now I remember that. I kept calling you Robertson before in
Yes, sir.
injunction court. All right, so it's Rober or Robert?
Robertson.
Robertson. Okay, I just expected there to be a second B there, or it's my fault. All right, Mr. Robertson, I've received your plea agreement here in 24 CF 2001 for 1-count aggravated battery on a pregnant person. Is this the plea offer that you want to accept?
Yes, sir.
Okay. Are you currently under the influence of any alcohol, drugs, or controlled substances that could impair your ability to make this decision today?
No, sir.
And do you have any mental health issues or concerns that could impair your ability to make this decision?
No, sir.
Have you had enough time to go over this form with Ms. Merrifield?
Yes, sir.
Has she explained it to you?
Yes, sir.
Has she answered all your questions about it?
Yes, sir.
Did you understand it?
Yes, sir.
Did you sign it?
Yes, sir.
And are you satisfied with her representation in this case?
Yes, sir.
Has anyone forced, pressured, or threatened you in any way to enter this plea?
No, sir.
Anyone promise anything in return for your plea?
No, sir.
You understand by entering a plea that you give up your right to a trial and all the trial rights that are enumerated and you read in this report,
Yes,
in this
sir.
agreement. All right, and you understand you're waiving all potential defenses that you may have.
Yes, sir.
And what is your plea?
No contest.
This is the state's agreement spelled out?
It is, Your Honor.
All right, I'm going to accept your no contest plea as freely, voluntarily, knowingly given, withhold adjudication, 36 months probation, $40 per month cost of supervision, $967 in court costs, 50 hours of community service work, which may be bought out at a statutory rate as a donation to a nonprofit domestic violence center. I'm not telling you which one that is. But that's what it has to be. You might, if you're going to do that, you might want to talk to probation before you do to make sure they say,
Okay.
yes, that's an approved place to do that. Attend and show proof of completion of batterer's intervention program, a mental health evaluation, and any recommended treatment. No contact with the listed victim, Jennifer Robertson, except for communication through the Talking Parents app, solely for purposes of parenting your minor children that you share together, until such time a final decree of divorce has been entered in 24 DR 3030, which would dictate shared parenting and parental communication. Do you understand all that?
Yes, sir.
So there's not only the injunction case, there's a pending dissolution case, right?
Yes, sir.
Okay. Okay, but as I've stated before, it sounds like there's a temporary injunction for another 30 days from Tuesday. Make sure you follow those terms. Those kind of trump these terms as far as the no contact. So no contact at all from the injunction, based on what your attorneys told us.
Yes, sir. I do have a question.
Yes, sir.
In the injunction hearing we were in before, you did allow contact with her attorney for divorce purposes. That's still okay, right?
Yes,
Okay.
as long as you're not passing along messages, hey,
Yes, sir.
tell her I said I love her, or something like that.
Yes, sir.
I try to use the same example all the time, so it doesn't seem like I'm giving different examples to different people.
Yes, sir.
But if you say something like that, that could be a violation. I actually have seen cases where the violation is through the opposing lawyer, because it gets to the point of you can't just keep saying pass along a message.
Yes, sir.
Okay. All right. Anything that I've missed?
No, Your Honor.
Okay. Mr. Robertson.
Based on him having to pay for the evaluations, the mental health, and the batter's intervention, we request.
All right. Supervision will be waived. That'll save you $40 a month, Mr. Robertson.
Thank you.
We'd ask that the clerk's record reflect the waiver.
It will. All right. You have 30 days to appeal the judgment and sentence of the court. Make sure you talk to probation before you leave, Mr. Robertson.
Yes, sir. Thank you.
Also, this was a downward departure sentence based on an uncoerced plea bargain.
That's correct, Your Honor.
Okay. And that's 3 years probation.
So you're going to go to that table right there. That's all I have this morning, Judge. Thank you.
Ms. Mayfield. Mr. Nopes?
Go ahead and take Mr. Nopes, Judge.
Of mine, I still need to talk to the state about Anderson. Michelle Kamp.
Oops. Thank you, Mr. Nopes.
Do you have a score sheet? Did I give you a score sheet? Did
I
I give
don't
you
have
a score
one.
sheet? No?
There's no probation or anything. It's just pay costs within a year.
Sorry?
Pay costs within a year is what it says?
Yes, sir.
Okay.
But she's had some medical issues and she's.
Fine. I'm just making sure I've got it
Yeah,
all.
yeah, I just want to make sure you understood why.
And that'll be a guideline sentence. I know you're working on the score sheet, but
I believe this would be a downward departure.
based on plea bargain.
Yes, sir.
Okay. Ms. Kemp, can you raise your right hand, please? Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right, we're here in 24 CF 328. I've been handed a plea and sentencing agreement regarding failure to report with the sheriff's office regarding your offender status. Is this what you want to do today?
Yes, sir.
Did you go over this form with Mr. Nopes?
Yes, sir.
And did you understand it all?
Yes, sir.
And you understand it calls for you to be adjudicated guilty, so you'll have this will be a felony conviction. You understand that?
Yes, sir.
All right. Are you currently under the influence of any alcohol, drugs, or controlled substances?
No.
All right. Do you have any mental health issues or concerns that would affect your ability to make this decision for yourself today?
No, sir.
Are you satisfied with the work of your attorney, his advice and representation?
Yes, sir.
Has anyone forced, pressure, or threatened you in any way to enter this plea?
No, sir.
Anyone promised you anything in return for your plea?
No.
You understand that by entering a plea, you're giving up your right to a trial where the state would have to prove beyond all reasonable doubt that you've committed this offense?
Yes, sir.
And you understand you're giving up all the trial rights that are enumerated? It looks like there's a check mark next to each one of them, probably as Mr. Nopes went through them.
Yes, sir.
And what is your plea?
Guilty. Or non-contest, I'm sorry.
Form says no contest.
Yes, sir.
All right. I'm going to accept your no contest plea as freely voluntarily knowingly given. Adjudicate you guilty. Time served. Court costs. $515 in court costs. You were appointed, or no, Mr.? Not appointed, all right. 817 total in court costs. I'll give you 1 year to pay those off, otherwise they'll be sent to collection. Any other questions or concerns? All right, is that the score sheet? All right, score sheet shows 45.9 months lowest possible prison sentence. So this is a downward departure based on an uncoerced plea bargain.
That's correct, Judge.
All right, Ms. Kemp, you have 30 days to appeal the judgment and sentence of the court. Make sure you get those costs paid in the time given.
Yes, sir.
All right, next, Mr. Nopes.
J.C. Rycroft.
J.C. Rycroft.
President, the state and I've spoke again this morning. Judge, we've agreed to put this on for February, I guess is it 24th?
24th for pretrial.
Yes, sir. We're probably going to take the deposition or at least go to the jail and talk to the alleged victim.
Alleged victims in the county jail.
That's what we think.
Yes, the victim, it's.
That's fine. I just want to make sure I heard it right. All right, February 24th, 9 o'clock. Stay in touch with your lawyer, Mr. Rycroft. We'll see you back on that date. And you've got one more you're going to come back on? Take your time.
A few minutes to talk to you.
Take your time. Mr. Powell, do you have something? Morning. It's DUI related? That's a DUI?
It's Cynthia Miller, and it's a DUI.
Okay, so that's your probate, you're gonna get all those things figured out? We don't normally handle very much in felony court. It's okay. He's just trying to work out Miller with you.
That's right. Yeah, if we could maybe just, I could just use a couple.
Oh, okay. Do we have anyone else we can take before we take a break?
Judge, we can recall Mr. Holmes.
All right.
Judge, Mr. Holmes is not going to be able to come back this afternoon. He's got a job interview.
Okay.
But he is going to accept the state's offer. It's a little bit up in the air. He's going to be entering a plea to 2 misdemeanors. It's going to be a year probation on each, running
Doing that
consecutive.
today?
Excuse me?
Is he doing that now?
He would like to go ahead and do that now. I don't have any blank plea forms with me, though, Judge, so you'd have to do an oral colloquy.
Well,
Mr. Notes may have one he can get.
Based on the back and forth over several court dates, I'd rather we can write it up if we could. I want to certainly get him out of here so he can get to his job interview this afternoon.
Mr. Notes has one. I'll draft it up.
And then
Come on back, have a seat.
you have anyone else we can call? I saw her earlier, but.
She's supposed to be back in front of John Cleric by 11.
She went to, if I may, Your Honor, I know that she went to speak with one of her clients, Christina Russell, for a new offer that I made, so that case may be resolved.
That's fine. We're not in a huge hurry. Haven't 10:30 yet. Ms. DeVee, did you have something that you wanted to bring up? Yeah. You judge got that division whipped into shape pretty quick, huh? All right. So do y'all want to take about a 10-minute recess and?
As Your Honor wishes, that's fine.
It just doesn't seem like we've got anything we can really handle until y'all either talk or Ms. Flowers comes back. Ms. Flowers, are you ready with anything? Ms. Flowers, are you ready with anything, or you need some time?
I can do, sure.
That's fine. So let's take the 2, then we'll take about a 10-minute recess, and then we'll come back and see if we can wrap up the docket.
Green. Green. Your Honor, this is Gerald Green in 24 CF 2150. We set him on today because he was brought to to Fort Walton Beach the other day, and I believe he's prepared to enter a no contest plea as charged for the 90 days jail, adjudicate 90 days jail. We've gone over the agreement and the terms previously, but he just needs to sign. Got the score sheet. That's correct. Okay, may I approach?
All right. Mr. Green, can you raise your right hand? Do you swear or affirm that the testimony about to give is the truth, the whole truth, and nothing but the truth? All right, 24 CF 2150. I've been given a plea and sentencing agreement for battery on by a person detained in a jail facility, third-degree felony. Calls for 90 days county jail with some costs. Is that what you want to do today? Okay. Yes, sir. I don't know what that number is, but you'll get credit for any credit you have on this case. All right. Are you currently under the influence of any alcohol, drugs, or controlled substances? Any mental health issues or concerns? All right. Could you speak up a little bit or pull that microphone over? I can hear you, but if I can barely hear you, it means the microphone might not be hearing you, so I want to make sure everything's on the record. Have you gone over this plea and sentencing agreement with your lawyer, Ms. Flowers?
Yes, sir.
Has she answered all of your questions?
Yes, sir, she has.
Did you understand the agreement?
Yes.
And you just signed it here in court?
Yes, sir.
All right. Are you satisfied with her advice and representation?
Yes, sir.
Anyone force, pressure, or threaten you in order to get you to take this plea?
No, sir.
Anybody promise you anything for your plea? Do you understand by entering a plea there won't be a trial of any kind, and you're giving up all your trial rights that you read about in this agreement?
Yes, sir.
All right. Any questions about those?
No, sir.
All right. And you understand you're waiving any potential defenses that you may have?
Yes, sir.
All right. And what is your plea?
No contest.
All right. I'll accept your no contest plea is freely, voluntarily, knowingly given, adjudicate guilty on the third-degree felony battery by a person detained in jail, 90 days jail with credit for all time served. It says concurrent. Is there another sentence that he's already served?
I went to.
You can end it.
I went to Fort Walton Court. Tuesday, and I was supposed to be to court here, but I went to credit, and they gave me time served for that too.
Okay, so the 90 days will be concurrent with anything that you're
Yes,
currently serving from your Fort Walton case.
Yes, sir.
All right, $967 in court costs, $150 cost of defense. All those monies will be to collections. All right.
That is a downward departure sentence based on the legitimate plea, Judge.
Thank you.
All right, and so you scored a minimum of 40.5 months, so the plea agreement got you the 90 days. You understand that?
Thank you, sir. Yes, sir.
All right, step over will be fingerprinted. You have 30 days to appeal the judgment and sentence of the court.
And this is Stephen Dwayne Sykes on the docket today on a VOP in 23 CF 79. Your Honor, for purpose of today, we'd just like to enter a denial and set for the next miscellaneous date. I believe I need to discuss with the case, there might be a Keaton offer, but I need to get him evaluated.
Keaton offer?
Yes, if that's, but I need to discuss that with my.
You want to set this with subpoenas for an evidentiary hearing, or just?
No, Your Honor, just without subpoenas.
I think we've been doing February 6th. All right, again, if something works out ahead of time, you can certainly try to bring it in earlier than that, but February 6th. All right. Any questions, Mr. Sykes?
Just to clarify, Your Honor, just briefly, my understanding is the issue for Mr. Sykes is largely restitution, not necessarily Keaton. Does probation have a recommendation for Keaton?
I don't want to go, Keith.
Yes. So my understanding was that we would be, the offer essentially is to adjudicate, reinstate, and modify 2 years community control, followed by about 2.5 years probation, whatever the maximum jurisdiction is. To give him and order monthly minimum payments for that restitution, since it's such a hefty amount. Just to clarify.
Okay, that, I was not, that, it appears that that's what, something he wants to do, so,
Your Honor, let me, if you don't mind, let me look at this for a second.
Okay.
Because it's a restitution deal. Him going to Keaton ain't gonna help.
Yeah.
Why don't y'all talk about this one over the break, and then we'll
Yes.
readdress it.
yes,
Yes, sir.
I might have
Just to make
been-
sure everyone's on the same page. If it's something
We're gonna
that's
take a
about getting
break,
him out
and I'll talk
today,
to the
then let's
prosecutor,
talk
and then we'll
about
bring
it.
you back out, okay?
All right, we'll
We'll
be
clear that
in
up.
recess for about 10 minutes.
All rise, please.
Serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
I'm Amanda Gaskin with Briar Patch Realty. Helping qualified heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
For more than 70 years, the sweet aroma of the Crestview Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
This is Tiffany Woodham, State Farm's newest agent in Crestview. I'd like to personally invite you to stop by my office for a no-cost policy review. Let me help you start saving today. Call in, walk in, or click in at yourcrestview.agent.com.
Alex Barthay from the UPS store once again, and I wanted to let you know about our Sunday hours. We're open now 7 days a week. Normal hours that you've been expecting, but now we're open Saturday 10 to 4, Sunday 10 to 3, and it's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
For years, I proudly served Florida as a state trooper. During that time, I investigated over 1,000 car, motorcycle, and trucking crashes. My mission was simple, to help the victims. Now, as an injury attorney, I can do even more to help accident victims. Hi, I'm attorney Coy Browning. If you've been injured in a car accident, I'd be honored to help you. Call or visit us at browninglawfirm.com.
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just 1 block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
Hello, this is Chris Norman at Bulldog Bail Bonds. Our office is in Crestview, Florida, but we service 7 Northwest Florida counties. If you ever find yourself in a jam, please give us a call. We're here to help you out.
Congratulations, Crestview's very own Dixie Dan Powell of Powell Injury Law, for your recent jury verdict of $11.5 million for your client from a death and injury against an inflatable amusement company. Recognized in 2017 as one of the top 100 civil trial lawyers in the state of Florida, and Dixie is AV preeminent rated. Dixie Dan Powell works tirelessly for his clients, as is evident by this extraordinary verdict. If you're taking your case to trial, be prepared. Contact Dixie Dan Powell and Powell Injury Law, 850-306-2667.
Cyclone Bakery Cafe is 2 blocks from the courthouse on Crestview's historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
I'm Amanda Gaskin with Briarpatch Realty. Helping qualified heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
For more than 70 years, the sweet aroma of the Crestview Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
This is Tiffany Woodham, State Farm's newest agent in Crestview. I'd like to personally invite you to stop by my office for a no-cost policy review. Let me help you start saving today. Call in, walk in, or click in at yourcrestviewagent.com.
Alex Barthay from the UPS store once again, and I wanted to let you know about our Sunday hours. We're open now 7 days a week. Normal hours that you've been expecting, but now we're open Saturday 10 to 4, Sunday 10 to 3, and that's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
For years, I proudly served Florida as a state trooper. During that time, I investigated over 1,000 car, motorcycle, and trucking crashes. My mission was simple: to help the victims. Now, as an injury attorney, I can do even more to help accident victims. Hi, I'm attorney Coy Browning. If you've been injured in a car accident, I'd be honored to help you. Call or visit us at browninglawfirm.com.
On behalf of Christina Russell and 24 CF 1569, we were set for a bond hearing today, but we have reached a resolution with the state for a plea. And I've gone over this plea with Ms. Russell and all the terms of probation and all of her rights. She just needs to sign, which she's going to do right now. May I approach?
All right, Ms. Russell, can you raise your right hand to be sworn, please? Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth? All right, you're here in 24 CF 1569, currently charged with burglary of an occupied structure as well as grand theft, both third-degree felonies. Do you understand that? All right. Plea calls for you to plead to a lesser on count 1 to attempted burglary and as charged as to the grand theft. Is that what you understand? Did you go over this agreement with your lawyer, Ms. Flowers?
I did.
Did you understand it all?
I did.
Did you read it?
Yes, sir.
Okay. Did she answer all your questions regarding it?
She did.
Okay. And are you satisfied with her advice and representation? All right, good. And are you under the influence of any alcohol, drugs, or controlled substances?
I am not.
All right. Any mental health issues or concerns?
None.
Okay. And you seem to be happy about this. Okay. All right. Anyone force, pressure, or threaten you to do this?
No.
Anyone promise you anything in return for your plea?
No.
You understand if you enter a plea, there won't be a trial of any kind, and you'll be giving up all of your trial rights that were enumerated here in the report, in the agreement.
Understand.
All right, and you're waiving all potential defenses that you have. Do you understand that?
Understand.
Okay, and what is your plea?
No contest.
No contest.
No contest. That's what's checked here on the form. All right, I'm gonna accept your no contest plea as freely, voluntarily, knowingly given. Count 1 is a lesser included of attempted burglary, adjudication of guilt, 3 years standard probation. Testify truthfully in the case that's listed. Anti-theft. Is that what it says?
Yeah, anti-theft course. Sorry.
Anti-theft course, okay. 615 in court costs. Count 2 is adjudication of guilt as charged of grand theft, 3 years probation concurrent with count 1. No trespass at 4050 for Don Boulevard. And then are we ordering restitution and reserving an amount?
Yes, Your Honor, we're reserving on the amount.
Okay, I'm going to order restitution reserve as to the amount for a period of 90 days. All right, cost of supervision will be waived due to the fact that you were represented by Regional Office of Conflict Counsel. Is it $515 in court costs or $615? $615 court costs, and then $150 PD fee on the application. But it was an attempted, so it drops it down a degree to third.
And can I just make one thing clear for the record, that the state will not be filing on the failure to appear?
That's correct, Your Honor. I'm not gonna.
Okay, so it's not filing on the failure to appear.
Thank you.
All right, was that the state's agreement?
Yes, Your Honor, it is.
Okay. And Ms. Russell, you were currently looking at, even with the amended charge, minimum of 18 months in prison. Did you understand that? All right, so this is a uncoerced plea bargain. Okay. And that's years probation. All right. And it's adjudication of guilt as to both, like I said. You need to talk to probation before you leave, be fingerprinted, and you have 30 days to appeal the judgment and sentence of the court. Thank you, Ms. Russell. All right, what do we figure out for Mr. Sykes?
Well, Your Honor, I've talked to the state, and there is an offer to modify and extend probation, to modify it to 2 years of community control, followed by 2 years of regular probation, with a $250 per month paid towards the restitution, basically giving him an extra 4 years to pay the large restitution amount and complete all original requirements. My issue is I did not anticipate this, and I don't have a plea form. I don't know if one is required for a modify and extend, or if the...
I think we can get through that. I mean, I just want to see.
When I do that. Yes. And Your Honor, actually, on second thought, after just talking to my client, can we just continue this until the next miscellaneous date for me to discuss what an alternative?
There's no objection to that, Judge. Mr. Sykes?
Well, my concern, so he pled to first-degree misdemeanor and a third-degree felony, right? And how much probation did he initially get?
He was given 12 months on the misdemeanor, count 1 battery, and 18 months on the grand theft. And that was in April of 24.
Okay.
He had a technical violation, was reinstated, modified,
in June,
apparently.
and then
In June. My records show he hasn't had any kind of conviction for a felony offense. So I was trying to give him the opportunity to pay that restitution in good faith with that minimum, with actually imposing a minimum monthly amount that would try to get the victim made whole by the end of probation.
my concern was just because it's a 4-year extension, what was it initially? So make sure we don't go past 5 years on the third-degree felony. But it sounds like you don't want to come back to handle this.
Yeah, I think we want to discuss what the reasonable, if he's going to be able to pay, or if he wants me to seek a jail offer,
Okay,
if there
that's
is
fine.
one.
So I'm going to put it like we initially talked about on
Yes, thank you.
February 6th. Denial's been entered as to the violation of probation. All right, I'll see you back on that date, Mr. Sykes.
Okay, thank you.
And if y'all work something out, want to try and bring it in earlier, we'll see what we can do.
All I have.
All right, thank you, Ms. Flowers.
Morning, Judge. Bo Powell for Cynthia Miller. It's 24 CF 149. We're before the court on a violation of probation
Oh, I'm sorry. When I was talking about it being a DUI, it's a VOP. Okay.
Correct. Possession of controlled substance and count 2 is a DUI, it's a VOP. Ms. Miller is going to enter an admission to the violation of probation, and we have an agreement from the state, if I could approach.
Okay. And this is Cynthia Ann Miller?
Yes, sir.
Okay.
Judge, we did go through the plea agreement. She just needs to.
Okay. Thanks, sir. All right, Ms. Miller, can you raise your right hand to be sworn? Do the best you.
I put it back in.
Well, I'm just. Ms. Miller, do you swear or affirm that the statements, any testimony you give right now will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right, you can put your unshackled hand back down.
Yes, sir.
Okay. We're here on 24 CF 149. You're here on a violation of probation. So I just remember when I was a baby state attorney 100 years ago in Sarasota County, a woman did that, and she said Houdini as she put both of her hands, and I can't get it out of my head right now. So.
Copperfield.
Okay. You're here on a violation of probation in the possession of controlled substance and a DUI. The plea and sentencing agreement I've been handed calls for you to plead no contest, or I guess admit to the violation of probation, adjudication of guilt, revoke and terminate probation, 180 days county jail, credit for time served, and then to D6, your outstanding DUI conditions. Do you understand what that means?
Yes, sir.
All right, it means you still have to do all those things in order to get your driver's license back.
Yes, sir.
All right. Is that what you want to do today?
Yes, sir.
Have you gone over this plea agreement with Mr. Powell?
Sir.
And did you understand it all?
Yes, sir.
All right. Did he answer all of your questions?
Yes, sir.
And are you under the influence of any alcohol, drugs, or controlled substance at this
No,
time?
sir.
Any mental health issues or concerns?
Sir.
Anyone force, pressure, or threaten you in any way to enter this plea?
Yes, sir.
Anyone promise you anything in return for this plea?
Yes, sir.
You understand there won't be a VOP evidentiary hearing to prove that you've done things that they've alleged as far as violating your probation? All right. And what is your plea? Are you admitting or denying your violation of probation?
No contest.
Okay, well, I'm going to take that as an admission to the violation of probation, adjudicate you guilty on both counts, revoke and terminate your probation, 180 days county jail, credit for time served, concurrent to any other sentence. Do you have another sentence going right now? Okay, I think that's just in case from Mr. Powell.
Just in case.
D6, any outstanding DUI conditions that you have, and then there'd be a $100 VOP fee as well. All right. Any questions, Ms. Miller?
Sure.
All right, I'm going to have you step over. Does she need fingerprints? I don't know if okay, was the possession of controlled substance an adjudication back then?
I believe it was a withhold.
Okay, so it's going to be an adjudication now, so I think I do need the fingerprints for the adjudication on the felony charge, and then you have 30 days to appeal the judgment and sentence of the court. Ms. Miller, this is a guideline sentence.
Thank you, Judge.
Thank you, Mr. Powell. Anything else?
No, sir.
All right, thank you. Have a good day.
Your
Thank you,
Honor,
Judge. You
is,
too.
Outstanding fees to collect?
Yes.
Thank you, Judge. Have a good day.
Did you put on some kind of lotion or something? Okay. It just like all of a sudden hit me.
Judge, I've got Robert Wardell Anderson. Sorry about there, brother.
Yes, sir.
What was the same deal?
The same 47.25, just like I told you.
With 15 months time served?
I'm sorry?
With the 15 months time
It
served?
says you get your credit for time served. I don't put that months in there, whatever it is.
Okay, I'm just making sure.
I'll do it.
How you doing today, Your Honor?
I'm doing well. How are you, Mr. Anderson?
I'm just glad that I'm finally getting this over with.
Let's see. I haven't seen it yet, so we'll talk about it real quick, and then we'll
Yes, sir.
get you on your way. Thank you, Mr. Nopes. All right, so it's a guideline sentence of 47.25.
Yes, Your Honor, that's the score.
All right, Mr. Anderson, can you raise your right hand for me? Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right. Mr. Anderson, you're here in 23 CF 2338, currently charged with, I believe it was attempted homicide, but the plea and sentencing agreement calls for you to plead to a lesser included offense of aggravated bodily with great bodily harm and with a weapon, which is a first-degree felony punishable up to 30 years in state prison. Do you understand that? Okay. Plea agreement calls for a adjudication of guilt to be withheld. Is that right?
No. Says a judge.
Okay, it says adjudicated in one spot and withheld in the other, so I'm just going to cross through that.
Oh, you're right, Judge. I'm sorry. That's my plea agreement.
Actually, it says adjudication of guild. So
What it should be, Judge.
it's okay.
Adjudication.
I know you've been trying to work on this for the past week and a half, and I'm glad it's finally been resolved for you all. All right. So, Mr. Anderson, did you go over this plea and sentencing agreement with Mr. Nopes?
Yes, sir.
All right. And did he go through it all with you?
Yes, sir.
And I can see, as Mr. Nopes always does, he checks all these little rights that you're giving up. Did you understand all those? Okay. And did he answer all of your questions?
Yes, sir.
And are you satisfied with his advice and representation?
Yes, sir. Yes, sir.
Are you under the influence of any alcohol, drugs, or controlled substances? Do you have any prior mental health diagnoses that could impair your ability to make this decision for
No,
yourself
sir.
today? Anyone force, pressure, or threaten you to do this plea today? Okay. You hesitated. Is there something you want to tell me?
No, sir. I'm just tired of this judicial system here. I'm just want to go about my business, get it over and done with.
Okay. So no one's forced you to do anything? All right. Anyone promise you anything in return for your plea? You understand by entering a plea there won't be a trial of any kind, and you'd be giving up those trial rights like we discussed. All right. Do you understand you're waiving any potential defenses that you may have? All right. And how old are you, and how far have you gone in school?
30 years old, and I dropped out at 12th grade.
Okay. But you were able to read and understand this? Okay. And what is your plea?
No contest.
All right. I'm going to accept your no contest plea is freely, voluntarily, knowingly given. Adjudication of guilt. 47.25 months, Department of Corrections with credit for time served. $515 court costs, $150 court-appointed legal assistance fee. I'm going to send those to collection since this is a DOC sentence. This is also a guideline sentence. Anything that I've missed?
No, Your Honor.
All right, Mr. Anderson, step over, be fingerprinted. You have 30 days to appeal the judgment and sentence of the court. Thank you, sir.
Thank you, Judge.
Good luck, Mr. Anderson. Mr. Williams.
Yes, Judge. Kelvin Holmes.
All right, Mr. Holmes.
Judge, we've got a plea.
Okay, third time's the charm, Mr. Holmes.
My god-awful handwriting, so he's going to be entering a plea to misdemeanor assault and
I
resisting.
haven't sworn you to tell the truth, Mr. Williams, but that is the truth. You have some horrible handwriting. It's okay, I can read it. I'm used to reading these things.
Well, I'm.
You should see my notes when I'm trying to write as fast as y'all talk. Sometimes they look pretty similar. So
I am the reason why in Santa Rosa they send secretaries in with the attorneys to write on the file instead of letting the attorney do it. It's good to know that I've had some influence.
yeah, that is a great legacy, Mr. Lundy.
Thank you. So anyway, he's going to be pleading 6 months probation, followed by 12 months probation. So the probations will run consecutive. Okay. He's going to have to do the anger management course. We've agreed to no contact with either of the two women that were involved in the case. Mm-hmm. Their names are on the plea agreement.
I see that.
It'll be misdemeanor assault court costs, and I've tried checking all my cheat sheets, and I have probably 3 different answers for what that's going to be. So if Madam Clerk will announce it, and then
Is it
misdemeanor.
domestic related at all?
No, I originally thought that it was. But
I just want to make sure. I think there's different court costs if it's domestic related. It's going to, count 1 will be misdemeanor simple assault, 2nd degree misdemeanor. Count 2 will be resisting without violence, 1st degree misdemeanor.
That was one of the 3 numbers I'd come up with.
Yeah, it's the 151 and the 201. All right, Mr. Holmes, is that what you want to do today?
Yes, sir.
All right, raise your right hand to be sworn. Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right, can you state your name and your date of birth, please?
Kelvin Holmes, 08/15/2004.
Hearing all the 2000 dates, it's just mind-boggling sometimes. All right, Mr. Holmes, you've been charged with aggravated assault and witness tampering, but is there going to be an omitted information? Certainly that's to count 2. Witness tampering, I don't think resisting is a lesser included. I just want to make sure it's cleaned up as good as we can get it.
No, you're correct. Mr. Williams suggested that we use that. I'm fine with any misdemeanor lesser included.
I'm not sure if there is a lesser included witness tampering, is there?
Can she orally amend, Judge?
I'll certainly let her do so, but I think it's always best to clean it up on the other side as
Yes,
far as.
yes, I would amend that count to resisting officer without violence.
Okay. All right. And do you agree there's a factual basis for that, Mr. Holmes?
Yes, sir.
Okay. All right. Have you gone over this plea and sentencing agreement with Mr. Williams, your attorney?
Yes, sir.
Did you understand it?
Yes, sir.
Did he answer all of your questions if you had any?
Yes, sir. But I do have a question for you, though.
Okay. Go ahead.
Like, as far as, like, the court costs, like, is it, like, a time limit that I have? Because,
You're
like,
going to be on probation for basically 18 months, right? So you
Yes,
have
sir.
that time to pay. They usually want you done at least 30 days in advance, or is it more than that now?
It's 90 days.
90 days. So that's still 15 months. Make sure you have it all paid in that amount of time, so that
Yes, sir.
way, otherwise they'll send something that says he hasn't paid all of his obligations. You might have to come back to court, so make sure you take care of that. All right. Any other questions?
No, sir.
All right. Now, I think where I was is, are you satisfied with Mr. Williams' advice and representation in this
Yes,
case?
sir.
All right. Are you under the influence of anything right now?
No, sir.
All right. Any mental health issues or concerns?
No, sir.
Anyone force, pressure, or threaten you to take this plea?
No, sir.
Anyone promise anything in return for your plea?
No, sir.
You understand by entering a plea there won't be a trial of any kind, and you're giving up all of your trial rights that are here on the first page of your agreement.
Yes, sir.
And you understand you're waiving any potential defenses that you have to your charges.
Yes, sir.
All right. And what is your plea?
Plea is no contest.
All right, I'm going to accept your no contest plea is freely, voluntarily, knowingly given to count 1, lesser included of assault, count 2, amended charge of resisting without violence. It's going to be an adjudication on both counts. On the assault, it's going to be 6 months probation, and that's still with Department of Corrections, correct? Okay. And then on count 2, it'll be 1 year probation consecutive, which means you have 6 and then 1. That will get you to the point of 18 months like we talked about.
Yes, sir.
You've got to do the anger management course, court costs, which were again $622. Does that include cost of prosecution and PD fee? Okay, so $50 PD fee due to the fact that it's a misdemeanor, $50 application fee. Cost of supervision of your probation is waived. Order restitution reserve as to the amount for a period of 90 days. And then during the course of your probation, no contact with Miss Turner and Miss Dixon. You understand that?
Yes, sir.
All right, so don't reach out to them in any way, even through a third party.
Yes, sir.
All right, anything else?
No, Your Honor, that's
All
it.
right. This was a guideline sentence, obviously, because it's misdemeanors. Need to be fingerprinted, Mr. Holmes, and talk to probation first, and then you've got 30 days to appeal the judgment and sentence of the court. All right, thank you, Mr. Holmes.
Thank you very much, Judge. Judge, I believe that's all I have until 1:30.
Okay, do we have anything else? That's all you have?
And no pretrial detention hearings, correct, Your Honor?
As far as I know, no one's told me about anything.
Just making sure.
What did we do? Mr. Nopes had Aaron Zimmerman I had on my docket.
I believe I dismissed that yesterday. I did. I don't just believe it.
What's that?
I said I did dismiss that yesterday, not that I just believe that I did.
All right, so we have no pretrial detention. We'll have arraignment docket at 1:30, and then we'll just, as soon as that's done, go right into everything that we can handle. I think we put some things for 2:30, but
I think 2 matters, 2 cases.
Mr. McDonald and Mr. Gamble.